Carol Leonnig, Donald Trump has obstructed so many investigations that you can actually compare the last special counsel investigation into obstruction with this special counsel investigation into obstruction. We refer to it as the two prongs of the Mueller probe. And what seems to be the difference is that in Don McGahn, he had a lawyer who was skilled enough and smart enough, not just to take notes, but to have a chief of staff that took notes and to know where the lines were and to retain a very skilled lawyer to make sure he didn't cross any of them. In this case, it sounds like potentially this special counsel's trying to figure out if Bob and Corcoran came down on the other side of that line.
I think that's not far off, Nicole, but I also think we should be careful and say that the crime fraud exception that Jack Smith is trying to use to pierce the privilege that Evan Corcoran had with Donald Trump doesn't require a finding that Evan Corcoran engaged in a crime, doesn't require that Evan Corcoran knew what Donald Trump's intent to commit a crime was, if that was his intent. What Jack Smith is trying to find out is, what did Donald Trump tell you when you began crafting this obviously false and misleading assertion that you'd carefully searched, diligently searched, and there were no more classified records at the Mar-a-Lago property. Remember, we have to put some pieces together here about what the government knew about evidence of a crime to start with. In July, they have, by this point, video surveillance showing people moving boxes from the storage area. And that evidence predates, that evidence comes after Donald Trump has been served with a subpoena to turn over records, right? So Evan Corcoran is now being told, this is where you should search for documents. What did Donald Trump tell him about where the government documents were? What did he tell him about the totality of where he should be searching? What instructions did Donald Trump give his lawyer at that point? A lawyer that the government has come to distrust in the highest form. It doesn't mean that Bob and Corcoran were engaged in a crime. What they want to know is, we have evidence of a crime. Were you getting instructions that help build the evidence for that?
Carol, I have that. Let me read from that. This is from a DOJ filing. Through further investigation, the FBI uncovered multiple sources of evidence indicating that the response to the May 11th grand jury subpoena was incomplete and that classified documents remained at the premises, notwithstanding the sworn certification made to the government on June 3rd. In particular, the government developed evidence that a search limited to the storage room would not have uncovered all the classified documents at the premises. The government also developed evidence that government records were likely concealed and removed from the storage room, and that efforts were likely taken to obstruct the government's investigation. Just again, help us understand how this new reporting and this revelation fits into what they've known, it would appear, from predating May 11th and June 8th filings.
I think you're right, Nicole, to want to pull these dots together, draw them together. So there's a May subpoena. There's a June promise by Evan Corcoran. We've given you all the records. We've searched, and here's everything complying with the subpoena. There is a request and obtaining of video surveillance in July that shows that's probably a lie. And now Jack Smith, with all the evidence of obstruction, with all the evidence that records not only were likely being concealed, but ended up in the August raid being found to have been concealed. And some of them, some of our most highly guarded secrets in the national firmament. With all of that, Jack Smith is now trying, based on this new development, trying to button down what is all the evidence of that crime. Who directed it? Was it Donald Trump? Did he intend to conceal, and did he even mislead his own attorney, or did he embroil his attorney in the concealing of national security secrets? I think this indicates something important, which is dotting all the I's and crossing all the T's in an investigation that could end with criminal charges or could end with a finding that there is not sufficient evidence to prove obstruction at trial.
Harry, tell us how you see it. I'll put this out there on the table. Our friend Brandon Van Grack says this: these are final steps of the investigation. Manafort was indicted just a few weeks after Chief Judge Howell in D.C. ruled Mueller could use crime fraud exception. Shouldn't be a long delay for a charging decision once Chief Judge Howell rules on this one. Do you agree with that?
Well, first, yes, we're pretty far down the line. I wouldn't make Manafort the exact analog, because there's more going on here. But to Carol's point, she's exactly right. But I think that's the headline. The focus is not on Corcoran and Bob. So what happened here is they lie about the subpoena. That's flat out obstruction. They brought Corcoran to a grand jury and want to know, and they have some evidence that's independent of all this, that maybe there was fraud in the communications between Trump and Corcoran. They say, what did Trump tell you? He says, well, I refuse to answer because of attorney-client privilege. Smith says, fine, see you in court. And, you know, it's the kind of aggressive move you contrasted with Mueller up top that Mueller say wouldn't do. But it's got Trump and really Trump alone in the crosshairs. The question is, what was the communications from Trump? And were they, as you suggest, either, unless Corcoran decided to fall on his sword, giving Trump total deniability, possible, but man, that, you don't find that often. Then Trump's involved in this decision. Trump told him something, and it could be very strong evidence of obstruction. Just one quick point of process. The government just has to come forward with a little bit of a showing that there may be evidence of a crime, and then the judge, Beryl Howell, will decide whether more likely than not. That's enough to pierce the exception. Obviously, that's less than the criminal threshold. This is exactly what happened out in California last year with Judge Carter and the John Eastman docs, finding there's enough to pierce the attorney-client privilege.
Harry, not to sound like a non-lawyer who doesn't know what she's talking about, but don't we have this evidence of obstruction in full view? Haven't we seen it in the affidavit? And I read from one of DOJ's filings in the back and forth with Eileen Cannon. We know that the National Archives, I think, spent 11 to 15 engagements trying to get the stuff. We know Christina Bobb has sort of caveated to absolute death and oblivion, an attestation she gave. She's been before the grand jury. We know that she was concerned that she wasn't attesting to the truth. We know that when they went in, as Carol said, they found a whole bunch of stuff. We know from the storage camera footage that there was stuff everywhere and that the FBI knew exactly where it was. Don't we already know that Donald Trump obstructed the investigation into classified documents at Mar-a-Lago?
Everything you say is right, and don't kid yourself. In the last few years, you've earned a law degree several times over. But what we don't know, and it's a potential pristine and killer piece of evidence, what did Trump tell you before you signed that document saying we'd done a diligent search and turned everything up? If the answer, the real answer, is he wasn't involved, that's one piece of evidence that Smith doesn't have. But if, on the other hand, it's he said, just tell him this, I don't care whether it's true or not, now you have just a terrific piece of evidence that has to come from the mouth of the lawyer in front of the jury. That specific piece, Nicole, is not, we don't know one way or another yet, and it could be killer.
Frank Figliuzzi, clearly what becomes public so far down the chain from where the FBI investigators and DOJ comes into conduct with the potential criminal acts. But it seems, going back today and looking at the filings to obtain the search warrant for the court-approved search of Mar-a-Lago, that they clearly believed there was evidence that was pristine and pretty solid to obtain the warrant in the first place. What do you see?
Yeah, what I agree. Well, what they're doing here is absolutely nailing it down tight. That's what they need to do. Because remember, when you present this case to a jury, you're going to have to prove it beyond a reasonable doubt. So yes, we've got kind of prima facie evidence that there's obstruction here. And I'll note on the obstruction thing, there's so much buzz around the Pence and Biden documents in their residences or offices, and what is that impact going to be on Smith and potential prosecution for possessing or mishandling documents. But we don't know. But what we do know is this: as you've just pointed out at least twice now, the obstruction part of the document case is solid. and it's going to get more solid, it appears. The other thing I'll add and kind of tack on to what Harry said is this concept of, hey, you need more than a hunch. You've got to show a judge you've got some evidence that a crime occurred, as you're asserting. That's important here because this is while not, I wouldn't say this is rare to demand an attorney to testify and provide evidence against his client, but it requires high levels of approval at DOJ, very senior levels. I've overseen such cases. I've overseen searches of an attorney's office. And then I started thinking back, Carol talked about, hey, let's be careful. You don't need to show that these lawyers have committed a crime. No, she's right. You don't. But I'll tell you, I've had cases where the lawyer was embedded with the crime. And some of the language being used here, the legal services were in furtherance of a crime. That's very interesting to me. And I go back 23 years to my days in Miami and the cocaine culture, where we had lawyers being paid in suitcases full of drug cash. And yes, we were debating about going into lawyers' offices. But again, it's infrequent, requires high levels. And I'm certain if Jack Smith is doing this, he's got somebody talking. He's got more than what we just described about the videotape and people moving boxes after the subpoena. I think people are talking. And I think, the ultimate dilemma for a defense attorney is having to basically give evidence against their client. But now it's time for them to decide, do I like my career and my bar license? Do I like my freedom? They're really going through some things right now.